Good morning. It's Attorney Vince Davis, and today we're going to be talking in our morning office hours about a question someone asked me. And the question is, Mr. Davis, I have been told that I can't appeal a judge's decision. Why can't I appeal? Well, it may be semantics. Here in California, there are two types of appeals. Well, I call them appeals, but they have technical names. There's an appeal, which is a matter of right, where you can go to the Court of Appeals and they have to decide your case. And then there's a writ, all right? And a writ, for the most part, the Court of Appeals has the discretion to decide the case. And there is a special type of writ that we'll talk about that's only found in juvenile dependency cases in the CPS courts. And those writs, the court must decide. So, Section 395 of the Welfare and Institutions Codes gives you the right to file a notice of appeal, and it gives you the right to have an appeal on a final judgment. Now, the phrase final judgment or judgment is a unique term in every different type of or every area of law. In juvenile dependency cases, final judgment means that there is a judgment after the disposition hearing. So what I call the first module of the juvenile dependency process, there's the detention hearing, the jurisdictional hearing, and the dispositional hearing. Most courts in not in Los Angeles, but yeah, in Los Angeles, but in California, do the jurisdictional and dispositional hearing together. There is a hearing generally before the contested jurisdictional and dispositional hearing, and they call it, some courts call it a pretrial, some courts call it a jurisdictional hearing, but it's where you and the court get the report, the jurisdictional and dispositional report from the social worker, and then you and your attorney decide how you're going to proceed. If you're going to proceed by way of a plea, proceed by way of a full contest, or proceed by way of half plea, half contest. So those, after the dispositional hearing, you can file the notice of appeal, and you can appeal the dispositional orders, you can appeal the jurisdictional findings, and you can also appeal the detention hearing. Now, all of those can be appealed at one time. Now, some people will say, well, the detention hearing and what happened generally, but not all the time, becomes moot after the dispositional hearing. If you want to appeal the detention hearing, you have to do it by way of writ. And the writ has a certain procedure, just like an appeal. And the court, the appellate court, can choose to decide your case or not decide your case. It depends on how you and your attorney frame the writ and how much of an emergency it is and how much of an emergency you can show. Now, there's a little trick that I want you guys to understand here in California. If you're at the dispositional hearing and the court orders no family reunification services to you, you must file what's called an extraordinary writ. And there's a certain process which is different from most writs, different from other writs, and different from appeals. You have to file a notice of intent to file a writ within a certain amount of days. And I think it's either 7 or 10, but you got to check that. You file a notice of intent. I usually file it that same day before I leave the courthouse, so there's never an issue of whether it's timely or not timely. Once you file that notice of intent, the record is compiled by the clerk, and then you have a certain amount of days to file your actual brief. That whole process can take anywhere from 2 weeks to a month to sometimes 6 weeks. But you have to go over the timelines and the strategies with your attorney. Now, if you have a court-appointed attorney, all right, that court-appointed attorney is responsible for filing the notice of intent, if that's what you want, and responsible for doing the brief, all right? Back in the old days when they had something similar, and I'm talking years ago, the Court of Appeals would give you a court-appointed attorney on appeal to take care of all of this, just like they do when you file a notice of appeal. That changed by special rule. Now your trial attorney and your court-appointed attorney at trial is responsible for filing that writ. Now, any other hearing or order in the juvenile court is generally, and I want to emphasize the word generally, you can do it by way of a notice of appeal where the court must make a decision. So for example, let's say you have a 6-month review hearing and it doesn't come out how you expected. You want to file a notice of appeal. Talk to your attorney. A 12-month review hearing doesn't come out like you think. Talk to your attorney to file the notice of appeal. And if you're indigent, the Court of Appeal, at least here in California, will appoint you an attorney to represent you on that appeal. If you go to the 18-month date, 18-month review, court makes a decision, and if the court terminates your family reunification services, what do? Appeal, writ, or special writ? Special writ, because earlier I said if at any time the court decides to terminate your family reunification services, you have to file this special writ, the notice of intent, the records put together by the clerk, and then your brief. Okay, so don't file a notice of appeal if and when, anytime during your case, the court terminates your family reunification services. It always has to be that special writ. And that special writ must be decided by the court, unlike other writs where they have the discretion. All right. Any other findings during a juvenile court case are generally only reviewable by the Court of Appeals by way of by way of a writ petition, just an ordinary writ petition. Now, if you get to let's assume that your family reunification services have been terminated. That's the worst case scenario. And they set a 366.26 hearing to terminate your parental rights. There's a little strategy that I like to employ where applicable in a lot of cases. In between the dates, you and your attorney should talk and discuss the strategy for filing a 388 petition. In other videos, I've talked about the 388 petition. You can Google WIC 388 here in California, and you'll look it up and you'll read it and you'll understand what I'm talking about, because it tends to be a little bit more complex than people think. Don't try to do it yourself. Talk to an attorney, talk to your court-appointed attorney about filing the 388. If the court denies that 388 petition to give you more family reunification services, to give you better visitation, to return the child to you even, then you can appeal that. You may want to file a writ, but you can still, appeal that. Once you go to the 366.26 hearing, worst case scenario, you lose, your parental rights are terminated. It's kind of the death penalty for parents in juvenile dependency cases. You can file an appeal. Now, when you file the appeal, just like everything else in the law, there's a timeline, okay, that you have to comply with. So generally in the notice of appeal, it's a simple form. You can actually Google notice of appeal in California and you can come up with the form. Review it with your attorney though. You got to file the notice of appeal within the 60 days. Now there are different timelines for writs. Sometimes the regular old writ that you might want to file There's not a timeline specifically stated in the law, and I think reviewing courts look at it on a terms of reasonable basis. You know, the faster you file, the more likely you might get relief. Now, I've heard some people, in certain types of writs, I've heard people tell me, oh, there's a 10-day limit. That may be true for certain types of writs. It's not true for every type of writ. But regarding the notice of appeal, you only have 60 days. Now, and here's the kicker. If you don't file that notice of appeal with the court clerk in your juvenile dependency courthouse, you lose your right to appeal. So don't miss that 60 days. And all you have to do in California, the notice of appeal, as I recall, is a 2-page form. You only actually have to file the first page and fill it out. It just asks you some general information. I don't suggest that you fill it out by yourself. I suggest that you get your lawyer, court-appointed attorney, and go over the notice of appeal before you file it. It's a 1-page form. It will take less than 5 minutes. Okay? So that's about, oh, one last issue. Let's say that your parental rights are terminated, and you or a relative have waited this, lengthy period of time to go and ask the court to place the child with, a friendly relative or family friend. Those, and your rights are terminated. Those types of requests, if the court denies it, are only reviewable by writ. Okay, so please don't try to file a notice of appeal. You want to file a writ. Now, if you file a notice of appeal and you should have filed a writ, most likely the court will bump you out of court. It will just deny it because you've done it procedurally the incorrect way. So, this appeal and writ minefield is something that you usually can't navigate by yourself. So talk to your court-appointed attorney. If you need to find an attorney, look in your area, go on Google, type in juvenile dependency appeals attorney, and hopefully that will help you find someone. I just got a call from someone, and I had forgotten all about this. And it's like this in most counties, but it's definitely like this here in LA County. Let's say that you are looking for an attorney and you just don't want to Google it, okay? And you want somebody who you believe there has been some vetting of their experience before they're recommended to you. In Los Angeles County, the Los Angeles County Bar Association has something called the Lawyer Referral Service. And they have a list of juvenile dependency attorneys that can represent you that have been, somewhat vetted for experience. And they also have juvenile dependency attorneys that they can refer you to that have, some appellate experience. So it used to be free in the old days. I think someone just told me that it now costs $25 to get a referral, or I think 2 or 3 referrals. But it's well worth it if you just don't want to pick somebody off of Google who may or may not have the experience. Okay? And I say that for everyone in California, probably everyone in the United States. Call your local bar association, and it's usually a county bar association, all right? And just say, hey, do you have a lawyer referral service? And I bet $1 that they're going to say, yes, we do. What kind of attorney are you looking for? Now, there's no guarantee, of course, that they're going to say, we have a juvenile dependency attorney or we have a juvenile dependency appeals attorney. That's a very narrow and specific, I can't call it a specialty, but a very narrow area of law in California, as in the United States. So you want to get a guy or a gal who practices in that area and who has experience, because if you're appealing a case, that means you lost, or if you're seeking a writ, that means you lost. And this is really, really important because you might only have one bite at the apple. So make sure you have the right person helping you in the case. All right. I want to thank you for being on this morning in our early morning office hours here at 6:30 a.m. I will see you again this evening at 8:30 a.m. We'll have morning office hours. Excuse me, evening office hours. My name is Vince Davis. Take a look at my website, fightchildprotectiveservices.com. It has a lot of additional resources. Also take a look at my YouTube. Just put my name in the search bar. You'll come up with my YouTube channel. You'll get, you'll see resource videos that I do, sort of like this, where I talk about how to do things generally in a juvenile dependency case. And also check me out on Saturdays right here live at The Secret How to Fight CPS and Win. I live stream an actual radio show that I do for ABC, KABC 790 AM in Los Angeles. You can, yeah, every Saturday from 7 to 9 p.m. And also, it's live streamed at kabc.com. All right, have a good day. I have to appear for a trial this morning in juvenile dependency court, fighting the fight. And I'll see you folks this evening at 8:30 for morning office or for evening office hours.